In the meantime, our cameras are also in New Hampshire, where defendant Jason Lex sentencing is underway. He is accused of shooting his neighbor, Violette. Now, the jury acquitted him of attempted second-degree murder, but found him guilty of assault. This is over an argument over a snowplow between these neighbors. And so where we left off on the other side of the commercial break was with victim Violette addressing the judge. He's delivering his victim impact statement, and it's a pretty impassioned one. Let's go back in.
What kind of father is going to make his daughter watch that and make my daughter watch that? This man is not in his right mind. He's a methed out drug addict, and that's a fact. To do something like that in front of your own daughter, you are no man, you are a coward. All this over words and not the lies they testified to. I never threatened him and his family that night. That was their story to justify for him trying to execute me. The worst thing about this man is state and federally prohibited from owning a firearm. So how does he have the right to gun me down with one? This man should not have no type of weapons whatsoever. But that fact was hidden from you guys all by these guys. I pray that you give me justice, because everything else in this case has been bad for me. Everything has been pushed against me, okay? They hid everything. They did their little maneuvers. They made me the bad guy. I have not gotten justice because this man should have never had a gun that night, and he shouldn't have had a gun every night of his life, like he said. Everything he said on that stand was lies, and if you couldn't see through it, I don't know how they didn't. But me and you know the truth of what happened that night. We know the truth. And I hope you sentence this man to the maximum so he can learn you don't do something like that to anybody. Okay? Especially with your daughter right there watching you.
Thank you, sir. Thank you, counsel. Attorney Sisti. Thank you.
Thank you. Good morning.
Good morning.
I did submit a sentencing memo and a package to the court.
I just want you to know I reviewed the memo. I reviewed the package carefully. I read all the letters.
All right. No, I appreciate that, and it's, I think, an important aspect of what I'll be getting into during the course of my discussion here this morning. There's a few things I will not address. I'm not going to address Kyle's statement. The time to address Kyle was during trial. I will ask the court to pay particular attention to some of the personal letters that were sent in as attachments to the memo. These are difficult times for both families. I'm sure this court understands that. Yes, Jason has a daughter, and her message to you is at the very front of the attachments that were sent in. And I think you can appreciate that as well. A lot of people get impacted on these situations, not just the two individuals that are directly involved, but, you know, it does spread out. And I've seen this over the years where a lot of people are impacted. And I think you have to keep that in mind, too. Jason has a minuscule prior record. In fact, to to grasp at straws like a 2005 conviction as some kind of foundation for what is in essence a maximum sentence I've never heard of before in my life. And with regard to the firearm that's been discussed at some length and their extensive research that they claim to have done, the reality is that the Rochester Police Department themselves delivered the firearm in 2019. Now, I mean, we can go back and forth on this all we want to go, but it was actually delivered to a home by the Rochester Police Department. If you look at the sentencing prongs, and we always do this, we do have to look at an individual's past. And you know, the clients I stand up here before courts all over the state and all over the United States and in federal court, I'm always getting bashed over the head with prior records, with prior violent acts, with not learning their lesson. They've been in prison and then they come out and they reoffend. That's not what we're dealing with here. And I think to try to make this a case where you've got some habitual criminal running around the streets of Rochester is a gross exaggeration of what the reality is in this case. This was a situation that I don't think can ever be replayed again. I mean, you saw the videos. I'm not going to talk about what happened there. We had real testimony in court, all right, with regard to what took place, all right? It's an isolated situation, it's a terrible result, and it's totally out of character with Jason's background. There was no question. I mean, maybe we forget that this is also the guy that volunteered all of the video recordings from his house, that sat down with the police for over 2 hours that evening, that waited for the police to come, that cooperated with the police, that gave them no trouble at all, and was taken into custody. That's more like Jason. He takes care of people generally, especially his family, and that's the center of his life, his elderly parents and his daughter. And I think we can't forget that. He's also a productive member of society. He works, and he takes care of his neighbors, and those letters are in the exhibit that has been submitted to the court. I'm not going to go on and on about whether or not there should be hope or reward or some consideration for going through programs in court. But on one hand, the prosecutor's arguing about his violent tendencies and how he's so dangerous that he can't be in the community and he needs the maximum sentence. And then on the other hand says he shouldn't be involved in any programming or any consideration for time cuts during the course of his incarceration. That makes no sense. There are programs. They are designed to address what the prosecutor has been advocating a maximum sentence for. And he should get some recognition if, in fact, he goes through those programs. There is no reason to cut off that particular aspect of the sentence, Judge. I already discussed the 5-day difference on the pretrial credit. That's the other issue, but I think that's already agreed to. But the backstory in this case, Judge, is that if you project down 5, 6, 7, 8, 9, 10 years, 20 years from now, you're not going to see Jason Lex. He's not going to be in front of you. Quite frankly, he's a guy that if he was released tomorrow and moved into another neighborhood and became the neighbor of anybody else, there wouldn't be any problem at all. There wouldn't be any fear. There wouldn't be anything at all. All right? Zero. Quite frankly, you wouldn't have any problem with him being your neighbor. Just like his neighbors generally have no problem with him being their neighbor. Just like his employers have no problem with him being their employee. He lives a pretty boring life, quite frankly. But don't let this one episode define who Jason Levesque is, because that's not Jason Levesque. It's a terrible night. You saw it. I don't want to reiterate. I just don't want to retry the case. We've already spilled our guts on everything in this case, the prosecution and the defense, and the witnesses that decided to testify. So with that, Judge.
All right, so defense counsel making his arguments to the judge for his client. The judge heard the victim impact statement, going to consider everything before he makes his decision on the sentence for Mr. Levesque. We'll keep you posted on that. In the meantime, letting you know the testimony has just begun in Connecticut in the Preppy Party murder trial. Witness on the stand right now. We'll hit a break and go in together live.
Brutal murders of 4 University of Idaho students.
Oh my God, this doesn't happen here.
Detectives arrested 28-year-old Brian Kohlberger.
You could tell there was some off about him.
He was stalking them. He was hunting them.
Forget about motive. We don't even have a connection.
This trial will be on Court TV.
And I pray that we have justice.
The Idaho College Student Murders Trial. Live coverage begins this August, only on Court TV.
For you.
Welcome back to Court TV Live. I'm Julie Grant. We want to show you the cases we are tracking for you all across the country. Starting first in New York City, the government's case could wrap up today in the federal sex trafficking and racketeering trial of music star Sean Diddy Combs. We'll keep you posted on that. In California, we have got defendant Monica Sementilli set to be sentenced for the stabbing death of her husband Fabio Sementilli. The sentencing set to happen at 11:30 a.m. Eastern time. Her husband was a famous hairstylist in California, and the jury found that she conspired with her lover and a hitman to kill him. In New Hampshire, we have got the sentencing for defendant Jason Lex from the Bad Blood shooting trial happening right now. The judge just taking the bench to deliver his sentence. And in Connecticut, we have got the Preppy Party murder trial back underway after the weekend. We've got a witness in the box. This is over the fatal stabbing of teenager James McGrath. He is the victim in this one. So here's what we're going to do. Before we go into the Connecticut courtroom, let's go to New Hampshire and get the judge's sentence for defendant Jason Lex.
Thank you all. You may be seated. Hi, Mr. Levesque, will you stand up for me, please? So before I announce my sentence in this case, I do want to discuss a little bit the factors that I considered in my reasoning for reaching this conclusion I'm about to reach. I paid close attention during the trial in this case. I have read carefully the sentencing memorandum from your counsel, as well as all the letters that were provided on your behalf. And I've thought about all of the standard purposes behind sentences in New Hampshire, including punishment, rehabilitation, general and specific deterrence. And I'll tell you that I agree with the state on many of their arguments in this case. When you look at the range of conduct that can lead to a first-degree assault charge, the conduct in this case is some of the most serious you can imagine. And but for the grace of God, this is not a murder charge. It was only because of the amazing medical care that was provided to the victim in this case that we did not have a much worse outcome in this case. And so this is a very serious crime which has a number of aggravating factors. The horrific injuries that the victim suffered in this case, the harm to his family, the harm to his mental health. Second, this case involves the misuse of a firearm, and this court takes cases involving firearms very seriously. While you have a constitutional right to carry a firearm in New Hampshire, that right comes with serious responsibilities to use it appropriately. And the jury in this case found that this was not a case involving self-defense and you weren't justified in using this firearm. And the court is also concerned about the fact that you weren't supposed to have that firearm because of a prior domestic violence conviction. So those are serious aggravating factors in this case. On the other hand, there are some mitigating factors in this case which the court took into account, which includes the fact that you don't have a serious criminal record, that you have lived the bulk of your life without having trouble with the law. You have the prior, but you do have prior crimes that involve violence, domestic violence, and the prior criminal threatening case. I also recognize that to your friends and family that you're a source of comfort and help to them, but that can't outweigh the harm that your behavior caused in this case and the fact that you were not justified in using this firearm. And the court was struck by the evidence that I was able to observe in this case. It was clear to me that the victim in this case was turning and walking away from you, that at that point you had numerous options available to you other than what you did. And so when the court balances those strong aggravating factors and the mitigating factors, I don't think that this is a case where the maximum sentence is required, but something very close to the maximum sentence I think is required, because the mitigating factors, while there are some, are not very strong. And for that reason, I'm going to impose the following sentence. I'm going to sentence you to the New Hampshire State Prison for not more than 20 years nor less than 10 years. There's added to the minimum sentence a disciplinary period equal to 150 days for each year of the minimum term of the sentence to be prorated for any part of the year, and you will get 445 days of pretrial confinement credit. I am, however, going to suspend 1 year of that minimum sentence and none of the maximum sentence. So I'm suspending 1 year off the minimum sentence for a period of 20 years from today's date. And part of my reasoning for that is the state has requested, and I am granting a order of no contact, that you're to have no contact with the victim, in this case KV, date of birth 8/30/1986, or his family members. And that suspended sentence does put something over your head after the completion of the sentence were you to violate that no contact order. That remaining 1 year of the suspended sentence could be imposed against you. Additional terms of this sentence: you're to participate meaningfully in and complete any counseling, treatment, and educational programs as directed by the correctional authority or the probation parole officer. I am going to grant that you can get earned time credits under 651A22. I think this is important because I think it's important to give inmates a reason to be productive and to engage in programming while they're in prison. However, given the serious nature of these charges, I am going to cap the amount you can get of earned time credits at 180 days. So you're entitled to earned time credits, but the maximum you can get is 180 days of earned time credits. I am going to implement the no contact order with the victim in this case. Law enforcement agencies may destroy any evidence in this case, return any evidence to its rightful owner, and you're ordered to be of good behavior and comply with all the terms of this sentence. And that is the court's sentence in this case. Anything further from the parties?
Stiff sentence from His Honor. This guy's going to do at least 10, no more than 20 years behind bars for the assault of his neighbor, Mr. Violette, who we heard speak just a short time ago. I want to get some reaction now from our legal analyst guest. He's practiced on both sides of the courtroom. He's a practicing criminal defense attorney right now in the private sector, formerly a prosecutor. Attorney John Day is with us. John, good morning to you. Your thoughts on what we saw the judge just do?
Thanks for having me, Julie. Tough sentence. The judge basically said, don't bring a gun to a fist fight. He's acknowledging what he heard during the trial, which was you had a defense claim of self-defense, which the jury didn't buy. The judge said, look, you know, your actions were violent. The victim, Mr. Violette, did not have a gun. You had a gun. You're not supposed to have a gun. The judge is acknowledging that this was a violent encounter. And the trial testimony was that both parties may have been hotheads, but only one of them brought a deadly weapon to that encounter.